So hi again, everyone. So my name is Meta Under, and I am a compliance consultant for CCL. And with me today, I have my colleague, Suzanne. She's our data protection expert. And then we have Alberto. He is managing consultant, and Louis, who is also a managing consultant for CCL. So we're going to explain a little bit about the regulatory environment in the DFC. So I'm going to, why is this not? There you go. Oh, yeah, here's the disclaimer, but I'm just going to pass over to talk a little bit about the DFC. So the DFC was actually established back in 2004. And was created a part of Dubai's strategy to become one of to diversify their economic resources in the Emirate. And it was built upon, the principle of being efficient, transparent, and with integrity. And the DFC has actually, since it was created, it has become one of the leading financial hubs, I would say, in the Middle East, and has attracted a lot of attention from financial institutions worldwide, from big banks to small private wealth management companies. And one of the characteristics about the DFC is that it has its own civil and commercial law. It provides you with 100% foreign ownership, so you don't need any local to be a part of your ownership of your company as you do onshore in the UAE. And it has a high standards of laws, rules, and regulations. The DFC also has its own financial regulator, which is called the DFSA. Okay, which is called DFSA, and the DFSA was actually built upon the FCA UK's framework, their framework. So if you're familiar with the FCA's rules and regulations, then you would quickly find out that the DFSA has very similar rules, but it has since become its own unique, and create its own unique rules, I would say, but very similar to the FCA UK rules. The DFC has also its own court. It's dollar-denominated jurisdiction, which means that here you cannot, so you're not allowed to trade in dirhams, I think I'm gonna pass on to the next slide before I talk a little about yeah, so one of the unique things about the DFC as a financial free zone is that the DFC, as I said before, has its own laws. So it's not really sharing any other, rules or laws with the rest of the UAE or Dubai in general, apart from the federal criminal law. So it has its own, commercial laws, which covers, things like the corporate law, the employment law, as well as the data protection law, which Suzanne will talk about in a bit. So I'm going to pass the mic on to Suzanne.
Thanks, Meta. So yeah, just to tell you a little bit about the data protection law. The data protection law in the DFC is a relatively new law, so it's introduced in 2020. We did have a data protection law previous to this under the 2007 law, but it was based on a more basic data protection law. So the new law is based on GDPR principles. And so it creating this level of accountability for firms. So firms must be now accountable for their data, they must know where it is, and they have an obligation to protect it. It also gives individuals specific rights when it comes to their data, similar again to the data protection law throughout Europe. So individuals can now access all their personal data that they provide to companies. They can redact their data, they can ask for it to be restricted, they can ask for it to no longer be used or be erased, and they can ask for it to be transferred. Meta, can I ask you to go back onto the previous slide, please? Thank you. So all organizations that are centered in the DIFC must comply with this data protection law. This includes any data that's transferred in or through the DIFC is also under the obligation. So it means that if you're transferring data to a group or an outsourcing company and the data has come through the DIFC, they are also obliged to stay with the data protection law. So some of the main principles of the data protection is data security. Firms must now be responsible for the data that they have. And ordinarily firms rely on IT. That's no longer going to be a suitable option for firms within the DIFC. It now requires that all employees, IT, HR, and anyone that transfers the data now has a responsibility to keep the data secure, which means not allowing it to be accessed without authorization or removed, deleted, or changed without authorization. So it has this new responsibility to secure data. You also have a responsibility to report breaches. So if anything goes wrong or data gets missing, either accidentally or maliciously, you now have to report or record any breaches that happen to that personal data. So you must internally record all breaches that happen, whether that be an accidental email transferred within your group entity with information that recipient shouldn't have received. If it's opened and you can't guarantee that it's not been stored or reviewed by that person. But if it's a serious risk to the data subject or a potential risk, you may also need to report to the Data Protection Commissioner or the data subject themselves. Metap is flying quite far. Can I go back to 2 slides, please? Thank you. And the slide before, please. Thank you. So you also have an obligation to tell individuals why you're using their personal data. So you can no longer use that personal data freely as you wish, and you can't sign people up to using personal data willy-nilly. You now need to define what the purpose of your personal data is. So you need to explain to people using a data privacy notice the reason why you have that data, where that data is transferred to, who will receive that data, whether it's transferred internationally or to an international organization. You'll need to explain what rights they have when it comes to that data, whether you're using any technical measures such as AI to be able to sort their data. And you must also give them an avenue to be able to complain about that data. So that means access to an individual who is responsible for updating their requests, or whether that be the commissioner itself, if it's a serious breach or a serious issue that they want to complain about. So a lot of firms are quite concerned what this means to them. Obviously, you have to use personal data on your day-to-day business. When you're using personal data in a day-to-day business, that's absolutely fine. What this law is asking you to do is to be accountable for where that data is, record where that data is, know who you're transferring that data to, and use it for a legitimate purpose. And one of the legitimate purposes, which is obviously crucial to the way that we do business, is client KYC. When it comes to AML data, you are free to use the personal data for AML purposes and client KYC. It doesn't change the way you work. It will, however, change the way you think about that data. So possibly how you store that data needs to be in a safe and secure environment or with minimized access to that data. And you can't use that data for any other purpose. So if you explain to a data subject that you're collecting that data, so a new client that you're onboarding, that you're using it for AML purposes, you can't then use it for other purposes, for example, marketing, without telling them that you're going to use it for that purpose. And data destruction. So ultimately, when you have the data and it's no longer valid for use and the purpose is expired, or you don't need it for regulatory reasons, you must then destroy the data in a secure manner or return the data in some circumstances. And that means, shredding data, but it also means in terms of soft data, so where you store it in data rooms or on servers. You need to be aware of where that is, and make sure that that data is destroyed when it's no longer of use. As part of that, you will also need a data retention policy, which explains how long you keep the data for, who has responsible for that data, and exactly what process it goes through to be removed, so you're securely removing it. Everyone should understand in your organization, not just IT, how long you should be keeping that data and where it should be kept. So if you go on to the next slide, please. Thank you. Another obligation, as I mentioned, you've got general data security, so you should be assessing the risk of your business, what type of personal data you have, and making sure you have adequate cybersecurity measures, and you understand your risk. So you should be making assessments of the risk to all your personal data, where it's stored, where it's saved, and where it's sent to. You will also be required to keep a record of where that personal data goes to make sure you're familiar with where it goes to. And there's also an obligation to notify IT and compliance to make sure that the commissioner is aware of any issues or data breaches, or even when you change your processes internally. So one of the high risk areas, and one of the reasons why I want to bring it into this presentation, is virtual data rooms. Obviously, they're very, very suitable for our business, and especially because we're working in a digital world, and the risk is a lot higher these days because of that type of situation and the sophistication of cyber breaches. And obviously the reputational risk of those types of breaches as well, with the amount of data you keep in these rooms. Just make sure that your virtual data rooms have suitable contracts in place. You understand exactly what security measures are in place, because you are responsible for making sure that is suitable for your type of business. It also comes down to educating everyone within your organization to know when it's suitable to download information and how much information. You should only be downloading the information you need and removing it when you don't need it. So if you do need to download information onto your local laptop or printer, it should be used in a suitable manner and only used for that purpose. Another thing you need to consider is general storing information. You should limit the access to information to the need to know basis. And especially when it comes down to special categories of personal data, which is your higher risk information, such as political information, criminal records, health data. When it comes to HR data is particularly risky when it comes to these things. You should be assessing the type of storage options you have, minimizing the places where it's stored, and controlling the access to make sure it's securely accessed. And make sure people are under confidentiality agreements before they're able to access such type of information. You're required to keep a comprehensive inventory of where you have data, what types of data you have, and what security measures you have in place. And as part of that, obviously, you need to record all of this type of information in your data protection policy. This should be your go-to document, and it's no longer suitable to have kind of a catch-all document. This document needs to be specific to your business. It needs to be a workable document that people can go to if they have any concerns on how they're using personal data, where to store that personal data, and what the rules are around that personal data. This should be your go-to document. So it's really important that you keep this document up to date, and somebody has responsibility for this document who's a suitable person to be able to assess this type of document. In some circumstances, the law requires you to have a data protection officer to oversee all your operations, and obviously they would be your prime person to keep this document up to date. But the law also requires you to have a data protection representative on your website should any requests or complaints come in. That will be on the DFC public register, and that person will be contactable if anything goes wrong or gets missing. So you need to have this policy document to minimize your risk, to be a go-to document, and also to be compliant with the data protection law. One of the biggest jobs though with this data protection law, one of the biggest issues that is, and takes a long time to do, is the transferring of personal data. So as I mentioned, in the DFC, all firms are, they have to comply with the data protection law, which means that when you're transferring within the DFC, you can feel comfortable that they're treating your data in a suitable manner. But you do need to have a contract in place, a written contract in place that meets the processing agreement rules in the data protection law to make sure that you're transferring in a fair manner to that individual. And so everyone understands their obligation when it comes to that data. However, when you're transferring outside the DIFC, some jurisdictions, such as the ADGM, for example, You can also trust their infrastructure of data protection, so you can transfer just with a simple agreement. But if you're transferring, for example, to UE mainland or elsewhere globally, pretty much excluding Europe, you will need an additional contract in place. And it's a comprehensive document which explains your liabilities and obligations and the rules of processing personal data and the security promises that the organization makes. Because if you collect personal data now, under this law, you are responsible for it, no matter whether it gets transferred elsewhere. So you need to protect yourselves by putting these contracts in place. And that includes contract transferring within the group or to a contracted outsourcing party. It doesn't necessarily mean between a client, etc. So that's a very basic overview and a very quick overview. So sorry about that, but I will pass it back to Mehtap. Thank you very much.
Thank you, Suzanne. All right. So as I mentioned before, the DFC has its own financial regulator, and the framework of the DFSA, or the rules around by the DFSA, was actually built upon FCA's rules, as I mentioned before, but it has since basically created its own unique standards, I would say. It's an independent body, and it has a risk-based, I'm just gonna, how can I move this? There you go. Perfect. So it's an independent body, and it has a risk-based regulator who's actively seeking opportunities to reduce regulators' burdens in general. I have my piece issues, there you go. So the DFSA, basically, if you want to apply for a financial permission, a financial license, then you would need to go to the DFSA, and depending on the activity you will be doing, the DFSA will have different kind of categories of permissions it will put you under. And I will go next to, I will give the mic to Lewis, who will talk about the different categories in a second. There you go, Lewis.
Thanks, Meta. Hi, everyone. So I'm just going to talk on the different financial services that the DFSA regulate. So ultimately, the DFSA only regulates specific types of financial service. Those lists of financial services are on the screen now. And on the right-hand side, you'll see Cat 1, Cat 2. Cat means category. And the DFSA deemed that a Category 1 is a type of financial service that carries the highest type of risk. And a Category 4 carries the lowest type of risk. And at the very bottom, we have REP, which stands for Rep Office. And depending on your type of category and the risk of your category will determine your capital requirements and the level of systems and controls that a firm must have when providing those financial services. I did receive a brief description of each of the Accelerator participants, and I have assigned some of your names against some of those financial services, which you may or not be providing. I only had a brief description, but there's just some food for thought as to whether or not these companies or your companies could be providing a financial service. Feel free to ask any questions to delve into at the end of this meeting, either on the call towards the end or at a later date. I think Yasmin and Jodea will be sharing our details. So if you'd like to get in touch with us to explore in more detail your business model, so we can determine and help you define whether or not you're providing a financial service, which ultimately means that you would need to be regulated by the DFSA. I'll just work through some of these definitions with you. So accepting deposits, that is essentially banking activity. So if you are receiving deposits and holding deposits on account and ultimately paying interest out on those deposits, you are providing the financial service of accepting deposits. Zebra Technologies, I think you're in your description, you mentioned that you were a banking app, and generally, if you were to accept deposits and provide interest within your app, then you would be defined as a category 1. We have Toogly, who I believe is an invoice trading marketplace. And I have assigned your name against a number of different financial services because there are different models for your business model. You may be dealing in investments as a match principal, which ultimately means that your clients, when they trade those invoices, they are securitized, and that the buy side faces Toogly, the sell side faces Toogly. Once both sides agree to the transaction, Toogly simultaneously faces both counterparties and performs a transaction. So there is an element of risk there in that, because you could be counterparty to the transaction, you are considered as dealing in investments as match principal. Alternatively, you may be dealing in investments as agent, whereby you are committing both sides of the transaction with one another, but that the actual settlement of the invoice trade occurs between both counterparties. You may well be just arranging deals and investments, which means that you're essentially facilitating the transaction on the platform. You have no involvement in the transaction or execution of the transaction itself. You simply put two counterparties together, and you are essentially arranging a deal and investment by virtue of doing so. That also goes the same for linked capital markets. Based on your description, I feel that you could be arranging deals and investments and essentially facilitating an investment and putting two counterparties together to conclude a transaction. Arranging credit and advising on credit, which is a category 4 activity. This is essentially, you are not providing credit yourselves, but you are putting a credit provider and a loanee together, and you facilitate that credit facility. You stand in the middle. While you're not providing the credit, you are facilitating that credit facility. And by the descriptions provided, I believe that perhaps SilkPay, New Credits, Business Score, and Finso may be arranging credit and advising on credit. And I will just add at this point, you do have the opportunities to speak to the DFSA as part of being within the Accelerator. So I would recommend that these firms do delve deeper with the DFSA as to whether you are providing a financial service or not. And like I said, the offer is open for CCL to also provide that guidance and steer you in the right direction. Providing money services, so Bankax, Wizzy Money, Wala, Wafi, Instapay, CPay, and Ziwa Technologies. I feel that based on the description provided, you guys could be providing money services. In short, money services could be one of a number of elements, including providing currency exchange, providing money transmission, operating a payment account, executing payment transactions, issuing payment instruments, and issuing stored value. Any of those functions fall under the definition of providing a money service, and you would need to be regulated within the DIFC to perform those activities from the DIFC. And then finally, we have operating a crowdfunding platform, which is one of the newer types of financial service regulated by the DFSA. And again, based on the descriptions provided, I feel that Toogly and New Credits might be providing that financial service of operating a crowdfunding platform. And lastly, operating a rep office. If you intended to simply market a group financial product, so you may have your business operating elsewhere in the world, and you simply want to market the group company, you can obtain operating a rep office license, which would allow you to market your financial services from the DIFC. That's it from me, and with that, I'll hand over to Alberto, who's going to talk you through the various systems and controls a DFSA regulated firm should consider.
Perfect, thank you, Luis. Meta, can we go to the next slide, please? Thank you. So if your company is considered, based on their activities, to be providing a financial service, the DFSA would expect you to have certain systems and control in place that would be, in a way, specific to the type of activity and the type of category that you will have, but also general in nature. So there are certain systems and controls that apply to all different types of firms, regardless of the license that they have. And I will briefly mention what those systems and controls are and how firms could make sure that these are complied with. So first of all, with respect to risk management, the DFSA would like all firms to be able to identify what are the risks that they face as a result of the provision of the financial services, that those risks are assessed and certain controls are put in place to mitigate such risk. And all of this is done by having all these risks identified into a risk framework that would not only mention what are the risks, what are the probability of them happening, what would be the impact if these risks materialize, who would be responsible for overseeing these risks, but more importantly, what are the controls in place to mitigate the risk, and who would be responsible also for overseeing that these controls are actually working. Ultimately, the DFSA lays the responsibility of risk management to the board of directors. So then also the firm must have appropriate ways to provide relevant information to the board of directors to properly oversee how these risks are being managed internally. Also, the DFSA will expect all firms to comply with all the applicable rules and regulations, to have a compliance function that will be responsible of the day-to-day compliance of the firm. And this person has to have the relevant experience in the center with of course, knowledgeable of the rules and regulations in the DFC, but also authorized by the DFSA. So the DFSA will interview the relevant individual, and if they believe that it's fit and proper to do this function, then they will approve it. In addition to that, the DFSA would also expect firms to have a money laundering reporting officer that, similar to the compliance officer, will be responsible for the compliance of anti-money laundering rules and regulations of the firm specifically. This is also a function that it's approved by the DFSA, so the relevant person must have the appropriate experience. And both functions, the compliance officer and the MLRO, must be residents in the UAE. Business plan and strategy. So DFSA would expect the firm to know clearly what is the business plan of the firm, what are the activities, and that they will be providing, which clients are going to be marketed, what type of jurisdictions, etc. So the DFSA believes that unless the firm clearly knows what is the business that they are providing and where they're going, that they need to have some plan in place to be able to turn to the right direction and try to meet all the objectives that are set up in such a business plan. So this is a plan that must be reviewed on an annual basis. All the relevant stakeholders have to be involved in it, and then ultimately approved by the board. And then management information. So similar to what I mentioned earlier on risk, the DFSA lays the ultimate responsibility of compliance of AML to the board of directors. So the board of directors must have appropriate information provided to them on the relevant frequency to be able to properly oversee and have oversight of the activities being done on the firm on a day-to-day basis. The DFSA will also expect firms to have appropriate human resources to run the business. The DFSA would not tell you how many employees you should have, but it leaves the responsibility back to the firm and for the firm to assess how many staff they must have and that they have the relevant experience to provide the functions that they've been hired for. But there is it's a responsibility, as I said, to the firm to make sure that they have the appropriate staff based on their particular business, based also on the volume, on the nature of the firm, etc. So that's also an assessment that all firms must carry out. Specifically speaking, when it comes to the senior executive officer, which would be the CEO of the firm, the compliance officer, and the MLRO, the DFSA expects these individuals to complete at least 15 hours of CPD annually to make sure that they are keeping abreast of all the new tendencies, for example, from a compliance perspective, from AML perspective as well. But this is something that they must need to have to make sure that they are continue receiving training that would keep them fit and proper for the functions that they will be carrying out. The DFSA will also expect all staff to be aware of the conduct of business rules and to be able, so that the employees do not engage in any market misconduct, money laundering, or any financial crime activities. And firms must provide all their staff with the relevant training so that the staff is aware about what are those rules, what they can and cannot do to be able to comply with this requirement. DFSA will also expect firms to have a business continuity plan that will set up what arrangements the firms will have in case they, for any reason, for example, cannot access their offices, and to make sure that they continue to provide the services and that the clients are not affected as a result of this. This could be the case of roads being closed and then no one can access the office, or there's an issue with the building and then no one can access it. The firms must have a plan in place to make sure they know beforehand how to deal with these particular matters and how they make sure that these won't affect the normal business of the firm. And there are certain functions that the DFSA allows firms to outsource, so hiring someone else to do that function for the firm. But the function can be outsourced, but not the responsibility. So this means that even if firms have engaged someone outside to provide a particular function, the responsibility of complying with that function remains with the firm, and the firms must have systems in place to make sure that they oversee the activities and the performance of those outsourced functions, because the responsibility remains with them. Next slide, Meta, please. Something very important is that the DFSA would expect records to be maintained for at least 6 years. These records relate to all the different types of parts of the business. It could be the business plan, all the policies and procedures, client information, staff information, financial information. All of those must be maintained for at least 6 years. All these records must be maintained in English. As Metab said earlier, the official language in the DIFC is English, so all of these records must be maintained in English as well, and must be available within 3 business days at a request of the regulators. And when it comes to fraud, authorized firms must have a proper systems and controls to prevent fraud against the firm, and the firm must also adopt a whistleblower policy to help preventing fraud and other crimes. This is something very important because the DFSA will also rely on all the staff and people working within the DIFC to also be able to make them aware of of any cases where other members of staff are related in fraud, or the firm itself. When it comes to corporate governance, the authorized firms must adopt a proper corporate governance framework, which is adequate to promote the sound and prudent management of the firm. And this goes back to what I mentioned. So a proper corporate governance framework would allow all of the directors that are not involved on a day-to-day basis on the activities of the firm to have proper oversight of those activities and be able to challenge, if necessary, any decisions taken by the members of the senior management. Luis also mentioned earlier that depending on the category of the license that you will have, particular capital requirements that you would need to maintain at all times. So the DFSA would expect you to have that, but also to have a particular function like finance officer who will be responsible to monitoring these capital requirements at all times, and also notify the DFSA in case there's been a breach and those capital resources have gone below the normal threshold. And regulatory reporting, there are different ways that the DFSA would expect firms to report different matters. This could be by ways of questionnaires, periodic reports via the electronic prudential reporting system of the DFSA that deals basically with financial matters. There's also, all firms will have access to the e-portal, which is a system the DFSA uses to communicate with firms. So it's important that the firms have access to all of these systems, but also to have the relevant employees to be that are able to communicate on a timely basis any matter that the regulator would expect to know. So DFSA has, as you might know, the DFSA Innovation Testing License, which is a sandbox place where firms can test their innovative activities that could potentially be required to be regulated by the DFSA. This allows firms to provide these services on a limited environment where a lot of the requirements will be waived during this ITL license for the first year. But this allows firms to also make sure that they can build throughout this first year robust processes to be able to provide these services fully when they receive the full license. But that also allows the DFSA to be more aware and to look in more detail how these activities have been performed within first year of operation, and provide the full license to firms once they are ready to actually do it on a large scale. So mostly the eligibility for this license would be to fintech firms. There's an application that has to be made by applicants. That would be an ITL cohort application where you submit basic information to the regulator and explain them what you're planning to do. And then a more detailed ITL application once you have been accepted into the cohort with more detailed information about what are the systems and controls that you will have in place. DFSA, as I mentioned, could grant you temporary relaxation of certain regulatory requirements. There might provide certain also restrictions during the testing period about about the activity that you can make, the volume of the activities, and this testing period typically varies between 6 to 12 months. And as I mentioned, at the end of this period, if the FSA believes that the firm is ready to provide this activity without these restrictions, they will provide a full license to that particular firm. So different to the ITL process, I'm going to focus now to the steps that you need to comply with if you want to get fully authorized by the DFSA to provide financial services. First, you will need to determine what is the financial service that you intend to provide in and from the DIFC. Elaborate a detailed business plan that will explain the regulator, what is the activity, what are the clients that you will be targeting, what's your management framework, who are your shareholders and beneficial owners, what are the high-level systems and controls that you will have in place to make sure that you comply with the relevant rules and regulations, and a financial forecast as well. This business plan will be discussed with the DFSA. A draft DFSA normally gets submitted to the regulator so that they can review it on a high-level basis, provide comments to the applicant, so this can be addressed prior to the full submission of the application. In addition to submitting that regulatory business plan, separate forms need also to be completed. The form will depend on the type of category that you will have, but that will also provide more information to the DFSA on who you are and also the members of your board and the staff that you will have, and also details of how you're going to be doing particular activities. If you're going to be providing, for example, services to retail clients, if that's the case, how you're going to be doing and what systems you have in place to protect the interest of those retail clients. And in addition to that, you will also need to prepare and submit, in the majority of the cases at the time of that application, a list of your manuals, the compliance manual that will set up what are the key requirements that you have and how you're going to comply with it, AML policies and procedures, corporate governance, risk management framework, etc. Once you have submitted all those documents to the DFSA will review your application. You will have a period where you will be having comments from the regulator on certain areas that you might need to enhance of the regulatory business plan, or certain things that they think that you must change on how you're going to be operating, certain risks that they see as a result of the activity that you're going to be providing. And once all of these have been addressed, the DFSA will issue an in principle letter, which basically means that you will be provided with the financial license, provided you comply with certain conditions. And these conditions basically would mean, for example, establishing a company in the DIFC, opening a bank account, and certain other matters. So it could be, depending on the category that you could have, you haven't identified properly a compliance officer by the time you get your ITL, your in principle approval letter. So DFSA would allow you that once you have identified that person, it has been interviewed by the DFSA and approved, then that you can proceed and they will give you the full license. And the full license will allow you to operate without any restrictions, but of course there's a lot of requirements that you will need to make sure you comply with to be able to maintain that license. Next slide, Meta, please. There are different cost considerations depending on the type of licenses that you will be applying for. And this is just an example of roughly the costs for licenses depending on the category. Category 4 license will cost $15,000. Category 3D will be also $15,000. And it goes all the way up to $70,000 for Category 1 firms, which are the banking permissions. For DIFC incorporation, so yes, in order to provide services in and from the DIFC, you need to have established an entity, your company in the DIFC. Normally the cost for a financial or non-financial entity would be $20,000 to be able for the application to incorporate a firm. and $12,000 on an ongoing basis. But for fintech and or innovation firms, the costs are reduced, and costs will be around $1,600 for the incorporation and an ongoing annual fee of $1,500. As we mentioned, in addition to that, you need to have certain, can we go back, sorry, Meta? You will also need to have certain staff that are mandatory functions. There would be the SEO, as I mentioned, has to be resident in the UAE, compliance and MLRO that can be outsourced, but also resident in the UAE, and the same individual can perform both functions. And you will also need to have a finance officer, can be outsourced. This function does not necessarily need to be resident in the UAE, and you must have, of course, a board of directors if you are a subsidiary, but if you are a branch, you can rely on the board of directors of your head office. You will need also to have premises in the center, and also get internal and external audit functions that will be reviewing the activities of both the compliance officer and the finance officer. Next slide, please. And cybersecurity DFSA guidelines. So based on, well, the actual situation where a lot of people are working from home as a result of the COVID pandemic, DFSA has raised the importance on making sure that firms have proper cybersecurity risk management guidelines in place. So DFSA would expect all regulated firms to have this in place, to have them reviewed and approved by the by your board of director, and that these also are part of the annual reviews that you have in place for risk, for compliance. So these also need to be included for cybersecurity to make sure that the systems that are in place are secure, and that this can be tested and tweaked if necessary, to make sure that all the information that the firm maintains about itself, about employees, clients, and transactions are maintained and are secured and not accessed by anyone outside the firm itself. And this is the end of our presentation. Thank you very much for your time, and we'll be happy to answer any questions that you have.
So I think we have one question here from Hamdi Farah, who's asking if a company falls under the activity that falls under providing money services and they already have presence in another country and opening a branch in the UAE to target UAE customers, are the regulatory requirements the same as a company that isn't opening as a branch? I think I will give that to you, Luis. Yeah,
sure. So it depends on the extent of the activities that your DIFC office will be doing. If you simply intend to market the office, the group company, you would still require a DFSA license, and that license would most likely be the rep office license, and that would allow you to market from the DIFC. There are certain systems and controls that you would need to have in place, some of those of which Alberto covered, but not to the extent as some of the other category firms. So it's more, you can consider it a light touch license, but nonetheless, you would need to go through the approval process with the DFSA. If you intend to go one step further than just marketing and perhaps assisting with the account opening and having an ongoing relationship with the customers from the DIFC, then you would need a category 4 license, which is arranging payment services or arranging money services. And that, again, has a few more systems and controls required, some higher capital requirements than a rep office. And you would need to have in place a compliance officer, an MLRO, and a finance officer. in order for that to perform those functions. So if you want to get Hamdi, if you want to get in touch with me after this call, perhaps we can arrange for a one-to-one meeting on Sunday, and that offer's open to all participants if you want to discuss your business model. But in short, it's, are you simply marketing, in which case you will need to be licensed, but you would have very light systems and controls, or do you intend to have an ongoing relationship with those customers from the DIFC and assist with the account opening, in which case it's a slightly heavier duty license, and you would require certain personnel to be in place in the DIFC, most notably the compliance officer, finance officer, and senior executive officer. But either way, whether you're marketing or arranging, you would need to have some kind of regulatory approval from the DFSA.
Thank you. Louis, any other questions?
Okay, guys, if we don't have any other questions for the team, after a very comprehensive and very informative session, I think that's why you guys are not getting that many questions. I think we can then go ahead into wrapping the session up. So if anyone else would like to ask any questions, guys, please do so now.
I just want to add, Jasmine, is that to all the participants today, I mean, if you have any questions, you're more than welcome to contact us at CCL at any time. We'll be more than happy to any questions you would have for, you know, for applying for any license or just in general, just compliance questions. More than welcome to contact us at any time. If you want any one-to-one sessions, we can provide that too. Yeah, so happy to assist you. And we have had a lot of, you know, startups and fintech companies in the DIFC, so happy to help you guys as well.